Hey everyone, in this video I'm going to reveal what you need to know about removing a director or shareholder from your company, and if you're facing this situation right now, the steps you take in the next few weeks could either save your business or destroy it completely. Get this wrong and you can face massive lawsuits, wrongful dismissal claims, and even criminal liability. I'm Santiago Cueto, board-certified international business law expert and best-selling author, and in my decades of practice, I've helped business owners navigate some of the most contentious director and shareholder removals imaginable. I've seen cases where proper procedures saved companies millions and others where one misstep resulted in devastating legal consequences. So stay with me, because by the end of this video, you'll understand the 5 critical steps to legally remove a director or shareholder, the 3 biggest mistakes that could expose you to massive liability, and the valuation trap that most business owners never see coming. And I promise you, the employment law complication I'll reveal at the end could completely change your removal strategy. But first, let me be crystal clear about something. Removing a director or shareholder is not the same as firing an employee. This is a complex legal process that involves corporate law, employment law, securities regulations, and potentially even criminal law. One wrong move can trigger lawsuits that last for years. All right, here's step 1. Determine your legal authority and grounds. Before you can remove anyone, you must establish that you have the legal authority to do so and legitimate grounds for the removal. This isn't about personal disputes or personality conflicts. You need legally sufficient lessons. For directors, the grounds typically include breach of fiduciary duties, failure to act in the company's best interests, conflicts of interests, incapacitation, or persistent violations of company policies. Remember, directors owe a duty of care and loyalty to the corporation and all shareholders. Now, for shareholders, removal is much more complex because ownership rights are fundamental property rights. You typically can only force out shareholders through specific mechanisms like drag-along clauses in shareholder agreements, court-ordered buyouts for oppressive conduct, or squeeze-out mergers in specific consequences. All right, the key point is that you cannot remove someone simply because you don't like them or want control. Courts scrutinize these actions closely, and acting without proper grounds can expose you to breach of fiduciary duty claims, oppression remedies, and substantial damages. All right, here's step 2. Review all governing documents. Your company's articles of incorporation, bylaws, and any shareholder agreements are your roadmap. These documents often contain specific procedures for removal that you must follow exactly. For director removal, most states allow shareholders to remove directors by ordinary resolution, typically requiring more than 50% of voting shares. However, your articles or bylaws may set higher thresholds or specific procedures. The critical requirement is special notice, usually 28 clear days before the meeting where removal will be proposed. This gives the director time to prepare a defense and allows proper shareholder notification. For example, here in Florida, the meeting notice must explicitly state that director removal is the purpose of the meeting under Section 607-0808 of the Florida Business Corporation Act. For shareholder removal, look for buyout clauses, forced sale provisions, or specific triggering events in your shareholder agreement. Without these provisions, removing a shareholder becomes exponentially more difficult and expensive. And don't forget to check employment agreements if the person is also an employee. Director removal doesn't automatically terminate employment and vice versa. These are separate legal relationships that must be handled independently. All right, now here's step 3. Follow proper procedural requirements. This is where most removals fail. Corporate law requires strict adherence to procedural formalities, and courts will invalidate removals that don't follow proper procedures. For director removal, you must call a formal shareholders meeting with proper notice to all the shareholders. The resolution must be proposed at this meeting. You cannot use written resolutions for director removal in most jurisdictions. Now, the director being removed has the right to attend the meeting, speak in their defense, and circulate written representations to the shareholders. Attempting to deny these rights can invalidate the whole process. Now, document everything meticulously. The corporate secretary should maintain detailed minutes of all meetings, resolutions passed, and votes tallied. This documentation protects you if the removal is later challenged in court. Now, for shareholders, if you're using squeeze-out procedures, minority shareholders typically have appraisal rights, the right to have their shares independently valued and purchased at fair market value. Failing to provide these rights can expose you to a significant legal liability. Now, if you're finding this valuable, hit that like button and subscribe for more corporate law insights that protect your business, and make sure you stay until the end, because the employment law trap I'm about to reveal has blindsided even experienced business owners. All right, now here's step 4. Handle valuation and compensation issues. If you're removing a shareholder, you'll likely need to buy out their interest. This is where things get expensive and contentious. The valuation process can make or break your removal effort. Minority shareholders often receive a minority discount. Their shares are worth less than a pro rata portion of the total business value because they lack control. However, if the removal is deemed oppressive or unfair, courts may eliminate this discount or even apply an oppressive premium to it. Now, independent business appraisals are typically required to establish fair value. Both sides may hire their own appraisers, leading to expensive valuation disputes. Some shareholder agreements specify valuation methods or appraisers to avoid these kinds of conflicts. Now, consider the tax complications carefully. The departing shareholder may face capital gains taxes on the buyout, while the remaining shareholders or company may have different tax consequences. Now, depending how the transaction is structured, financing the buyout can be challenging. Few companies have hundreds of thousands or millions of dollars in cash readily available. You may need external financing, seller financing, or installment payment plans. All right, now here's step 5. Update corporate records and compliance. Once the removal is complete, you must update all corporate records and notify relevant authorities. This isn't optional, it's legally required. File the necessary forms with your state's Secretary of State or Corporations Division. Most states require notification within 14 days of director changes. Failure to comply can result in fines and other penalties. You also want to update your corporate minute book, stock ledger, and any certificates of incorporation or bylaws that list specific directors or shareholders. Notify banks, insurance companies, vendors, and anyone else who needs to know about the change in corporate leadership. And don't forget about ongoing contracts, agreements, and relationships. The removed person may have been a signatory on important agreements or had specific authority that needs to be transferred to someone else. Consider whether you need to issue new stock certificates or update shareholder records if shares were purchased as a part of the removal process. Now, here's the employment law trap I promised. If the director or shareholder you're removing is also an employee, the removal from corporate office may trigger wrongful dismissal claims, even if the corporate removal was perfectly legal. Employment law and corporate law operate independently. You might have perfectly valid grounds to remove someone as a director while having no grounds to terminate their employment. If they're also an employee, you may owe them notice periods, severance payments, and benefits continuation that could cost hundreds of thousands of dollars. Even worse, if the person has an employment contract or is in a senior position, they may be entitled to significant compensation for wrongful dismission, even if the removal as a director or shareholder was justified. For example, here in Florida, minority shareholders facing squeeze-out procedures have appraisal rights under the Florida Business Corporations Act that can result in court-ordered buyouts at premium valuations. The solution? Always analyze the employment implications separately and get independent legal advice on both the corporate removal and any employment termination issues. Removing a director or shareholder is one of the most complex and high-risk corporate actions you can take. But when done properly, it can save your business and protect your investment. Now, if you found this valuable, like this video and subscribe to my channel for more corporate law strategies that protect your business and minimize your legal risk. Because when it comes to corporate governance, what you don't know can absolutely destroy you. I'll see you in the next one.